Hi, my name is Hani Bushra. I'm an immigration attorney, and this is another video discussing immigration laws. Today, I want to discuss the proposed regulations changing the rules for obtaining a work permit during an asylum application or dependency of an asylum application. Today is November 14th. These rules were announced yesterday, November 13th. They are proposed rules. They're not yet law. They have to go through a period of comments where people can comment on them. Then they have to go a period where if the comments are very important or something like that, they have to be rewritten. And of course, there's also the chance that they can be stopped by the courts, that they are not correct. And my feeling and my understanding is that these will probably be stopped by the courts, just because some of these rules are flagrant disregard of existing laws and regulations, and they are meant to harm people rather than just regulate the issue of asylum. Now, the rules have different factors or different parts to them. I'm going to go through them really quickly. Again, I just want to make sure that you understand these are proposed rules. They are not in the books yet. Today is November 14, 2019. I want to just maintain that because some people think that these are the actual rules, but they're not. So the first change that's being proposed right now is that the waiting period for you to obtain a work permit is going to be 365 days, which is a year, versus right now it's 6 months. So at this point, if you have applied for an asylum case and you are waiting for an interview, or you had an interview and you're waiting for a decision, or you were transferred to an immigration court, you would wait for 150 days, which is 5 months, and then you apply for a work permit, and then it comes within 30 days, or after 30 days, I'm sorry, not within 30 days, after 30 days. So you'll have 180 days of waiting period, and then you get your work permit. This rule is proposing to make that waiting period for a whole year. It's also proposing eliminating the requirement that the immigration has to give you a work permit within 30 days from you applying and being eligible for it. So like I said, you had, in the previous case or the existing rules right now, you apply at the day 150, they have to issue a work permit after 30 days. Sometimes they're delayed, but there's a right for you to have it within 30 days from that. Now, this rule is not going to only extend the period for 365 days, but it's also going to end up saying that the government doesn't have to adjudicate your case in 30 days. And so you could end up waiting for 365 days and then applying for your work permit and then waiting another 2-3 months because there's some kind of delay in your doing this the application or processing the application in the correct amount of time. So that's number one. Number two is that if you are filing beyond the 1-year filing deadline for your asylum, that means that you have not filed within the last time, within 1 year from last time entering the United States, you are not going to get a work permit ever until the issue of the 1 year, and whether there's an exception to the 1 year, is adjudicated. There are exceptions to the 1-year rule. Some of these exceptions are people who are here on, for instance, a student visa, who are here for 2 years, and then after they finish a student visa, cannot go back to their home country, and so they are trying their best to find a way to stay here, and now they only can do asylum. If you are in such case and you've been here for 2 years, for instance, on your student visa, and now you're applying for asylum, you would not be able to get a work permit at all during the pendency of your asylum hearing. Even if it goes to immigration court, you're not going to be able to get that. If you're here for many years and then suddenly there's a coup in your country and now you're eligible to apply for asylum because things have changed dramatically in your country, and you would probably win your case, but it's going to take a number of years for you to win your case. During those years, you're not able to get a work permit because you have filed beyond the 1-year filing deadline. And so again, this rule is meant to hurt people, not to apply the law, okay? And it would end up costing people who maybe even stayed here legally, whether on a student visa or some kind of E1, E2 visa, the ability not to apply for asylum. Get work permit while they're applying for asylum. The other thing in the rule is that if you have came into the United States illegally, not through a port of entry, you jumped the wall, for instance, or something like that, and then you apply for asylum, even if it's within the 1 year, you're still not going to be able to get a work permit. You're barred from doing that. The next one is the big one, I think, for people who are right now with a pending asylum application and going to renew their work permits, because the next one applies for renewals and new work permits. and that is if you have a criminal conviction, you're not going to be able to get a work permit. And the word criminal conviction is defined very broadly. So, number one, if you have a felony, you're not going to be able to get a work permit. Whatever the felony is, even if it's not a violent felony, even if it's sort of like check fraud or something like that. And sometimes felonies and check fraud are dependent on the amount that you wrote on the check. So if you wrote, for instance, something like $10,000, in some states that's considered a felony. Okay. If you have a felony on your record, you are not going to be able to get a work permit while your asylum case is pending. If you have certain misdemeanors, including DUI, driving under the influence, including domestic violence or some kind of domestic case, neglecting your children, a case that was filed against you criminally, it's a misdemeanor or something like that, you're not going to be able to get a work permit. If you have cases that are still pending that have not been resolved in criminal court, you're not going to be able to get a work permit until they're resolved, or request some kind of discretion from the USCIS to give you an exception to this. This is going to impact a lot of people who are renewing their EAD or their work permit, because a lot of people have been here for years. They end up doing a mistake in their lives, and they're going to end up paying for it by not getting a work permit and not being able to support themselves and their families. The other requirements is that, or the other rule proposed change to the rule or to the issues of EAD or the work permit, is that if you have an appeal pending before the federal court, so let's say you applied for asylum in the asylum office, it got referred to the immigration court. In the immigration court, you lost your asylum case, you lost your case in the Board of Immigration Appeals. If you end up appealing to the federal court, and even though you had the right to get a work permit during the time all these things were going on, you're not going to be able to get a work permit anymore. Again, this is a change from the existing policy. The other thing is that if you end up missing your biometrics appointment or your interview for any reason, you're not going to be able to get a work permit, and you're going to be dismissed from your asylum case. And the asylum office is not obligated to warn you that you have missed your interview. And sometimes what happens is that they send an appointment letter. The appointment letter gets lost for some reason. Things get lost in the mail, okay? And, you end up not going to your appointment, for instance. But then you get a letter that says you failed to show up. You get that letter. It's another chance. It's another way. And it gives you 45 days to resolve the issue of why you didn't show up. That policy of giving you some time to resolve the issue of why you did not show up is going to be taken away. That's part of the proposed rules. And so these are the gist of the proposed rules regarding work permits. They're cruel, and I think they're meant to be cruel. They're meant to make people not apply for asylum. They're meant to make people think twice about applying for asylum and make it harder for people who are applying for asylum to stay here in the United States. We are trying our best as immigration attorneys to fight these rules. I would encourage you, if you have friends that are voting next year in elections, that you would let them know about these rules and how cruel they are and how hurtful they are, and how they are targeting the most vulnerable people among us, and encourage them to vote for the right people who are not cruel and who actually show the real American character of compassion and welcoming that we always have in this country. Thank you for watching our video. If you have any questions, please give us a call or contact us through any of the contact information that you have on your screen. Thank you very much.